Guys, welcome to the show. Deeds of Arms is for everyone interested in realistic close combat training, from marksmanship, bladed weapons, ground fighting, and so on. Our mission is to develop and create tactically proficient human weapon systems of high moral character through cooperative, collaborative, and competitive training. Guys, today I'm very excited. I have the second most handsome person to be on this show, and he is the combatives consigliere. He's my good friend Chet Palumbo. Chet, what's up, brother?
Hey, how you doing, John?
Hey, man. So yeah, I'm pretty happy to have you. You know, you've been kind of the invisible hand behind a lot of my legal material for a while, and we've deliberated over this stuff a lot, and we've talked a lot about, you know, where a lot of force and force instructors kind of miss the mark, or they're really good at dealing with the contact phase, right? But as far as creating in their systems or with their students, like that ability to articulate what they did and why they did it, we've talked a lot about that. Like, there's just guys that are, you know, I don't even want to mess it up, you know, but it's like basically simulating red rum, you know, on certain things. So, like, I mean, what do you see? What do you think when you see some of that stuff, man?
Man, I just think, you know, it's all cool. It's all fun and games. It, you know, makes you feel all pumped up and stuff until that stuff comes back to bite you, you know, and I don't think people think about how stuff like that can come back to bite you. But in these high profile homicide, self-defense cases, the investigators are out there. They're bringing everything that they can in your past and the people that you've affiliated yourself with, the people that you've trained with. It's a complete character assassination. So anything that they can, you know, it's kind of like that thing that people say, you know, text or email like it's going to be read at a deposition or read in front of a jury one day. At the same time, like, train and, you know, affiliate yourself and do things as if all of the things that you're doing and all the people that you're affiliating with is going to be put on a big screen in front of a jury one day in a murder trial.
So before we kind of move into that, let's back up a step. And what do you know about prosecution? What do you know about the legal system? Like, can you tell us a little bit about your background and, like,
yeah,
you know,
sure.
what makes you, what would say, why would someone say or talk to you about this stuff?
Yeah, no, that's a great question. You know, as far as the criminal side, I graduated law school in 2010. I was on law review, and so that's kind of for like the top 5 or top 10% of the class, where I authored an article on a criminal law issue. Began practicing law because of my wife's job. I've moved around, so I have had the opportunity to practice criminal law in 4 states right now. I was a prosecutor in Tampa for 2 years, where I did primarily misdemeanor and juvenile felony cases. As far as on the defense side, I mean, I've in defense and prosecution together, I've done a total of, I think the number's right at 45 jury trials as first chair. So that's not sitting with someone else taking notes. That is the primary person. So right about 45 jury trials. A handful of those trials were punishable by life. Cases where, you know, the person was looking at doing life if found guilty. And and then that kind of segue just into, you know, some martial arts training in the last 10 years, Brazilian Jiu-Jitsu and combatives. And so I just really like the intersection of law and then combatives, and then trying to think about the law as I'm training jiu-jitsu, as I'm training combatives, and thinking about how do I articulate or what would be the application of this particular technique or this particular concept in a self-defense scenario.
So let me ask you, just kind of working from the fundamentals, right? Working from the bare bones, like you're like, I really don't think people appreciate how cool it is that there's a guy like you that exists, right? That there's a guy who's a practicing attorney who's been done this, you know, from the criminal, from the, you know, from both sides of the aisle, right, so to speak. And then you're also practicing force on force stuff. You practicing marksmanship, so you've got a unique blend of being in a lot of different worlds. So let's we'll just kind of encapsulate all that. We'll call that kind of the self-defense world, right? Where do you think a lot of practitioners kind of miss the mark, or what do you think is the main concept they're missing as far as offering themselves kind of legal protection and making sure that they don't find themselves talking to a guy like you in kind of the wrong circumstances?
Sure. I think a lot of people know just enough to be dangerous. As far as the legal side, they know a few buzzwords, they know a few concepts that are out of context, and then they think they know the law, and then they sort of extrapolate that into a scenario, and they can come to a wrong conclusion. I'll just give you a very brief example. I can't tell you how many people I've heard say, well, in my state, if somebody comes into your house, you're allowed to shoot them. And it's like, well, there's a lot of protections for a homeowner. There's a lot of legal protections for someone in their home. You're going to get the benefit of the doubt, and we can talk about castle doctrine if you want to, but
right.
To just say as a blanket rule, if someone comes into your house or if someone comes into your property, I'm allowed to shoot them, is a false statement. That is not a correct statement of law. Mm-hmm. And what they're missing the mark on, and I'm not trying to go too far down the weeds on this one particular issue, but they're trying to encapsulate an aspect of the castle doctrine, which is the presumption of fear. Mm-hmm. Well, that's great and that's good. But if in your statement to the police, you say, the reason I shot him is because he was on my property, where you might have started off justified, you may have just talked yourself into a prison sentence now.
So how does that work too? Because this is that's something that kind of permeates the concealed carry community a lot. Of like, I remember it when my wife and I, when we first got our concealed carry permits, and that was a big thing that they were saying, and the concealed carry instructor was telling us, like, you articulate that, you tell them I was in fear for my life, or something to that, and I thought I was gonna die, or something to that effect, right? So, like, why is it important, or why is that something that you think it can end up where you end up talking yourself to where you're going to get a charge or you're going to get indicted or something like that?
Sure. So, like, if you're articulating that the reason that you shot was because, quote, the guy was in my house, or he came onto my property and he didn't have permission to be there. Mm-hmm. Well, all you've really articulated at that point is that there was a trespass. Okay. Mm-hmm. And that's all that you've articulated. And if that is the complete, if that's the exhaustive list for reasons why you shot, there's going to be a lot of questions about that, and that could be used against you. Now, from what you're talking about, the saying that I was in fear for my life, I thought I was going to die. That's great. And if that's the truth, that absolutely does need to be articulated. Mm. But where you and I have had a lot of conversations with is, I think, people that think that if they say those magic words, that they're just going to go home free. And that if you just say, I was in fear for my life, all of a sudden the cops are going to throw down their pens and paper and go, hey, guys, this guy said the magic words. Yeah,
we're done here, right?
He said the magic words.
Yeah.
And so that's just not the case. If you are in objective and subjective fear of death or serious bodily injury, you are allowed to use deadly force. Absolutely. And that does need to be articulated.
Yeah.
But that is the conclusion. You need to state the conclusion that I was in fear for my life, but you then need to be able to articulate the facts that led you to that conclusion.
Right. Yeah. And this is kind of the investigator moment where I'm asking the questions I kind of already know the answers to, but because these are you hear people, they'll read the law and they'll be like something, they're like, oh, well, reasonable fear, something like that. And they're like, oh, well, it's literally in the law. Because I took some heat a couple of weeks ago where I was like, hey, fear is not an objective self-defense. It's not a way to, you're not going to get off scot-free. You're not going to, you're not going to make the cops pack their shit up and leave and just like, oh, well, we're done here. We don't need to investigate further. And people were like, well, it says it in the law. It says specifically fear. Like, what do you say to something like that when people are like, oh, well, it says fear?
Yeah. So really need to understand the difference between objective and subjective fear of death or serious bodily injury.
Mm-hmm.
Subjective means you were in fact in fear, you yourself.
Mm-hmm. Yeah.
Objective means a reasonable person of average, I think the different states use things like of average bravery or average, character would have also been in fear. So I'll give you an example of where you might have one and not the other. If you were subjectively in fear because you overreact to things and you're terrified. Let's say someone has I don't know, a bag of groceries and you are super allergic to different spices and you are just irrationally fearful that some of the spices in that person's grocery bag might cause you to have an allergic reaction and go into anaphylaxis shock. You can't pull out your gun and shoot that person.
Yeah.
Even if you were subject, and an expert psychologist would testify, they honestly were in fear of death. Okay, then we shift to objective. But would a reasonable person have been in fear of death or serious bodily injury? And the answer is no. Right. And so that objective fear, when you articulate your subjective fear, it also needs to subsume objective, okay, well, a reasonable person also would have been in fear in that situation.
Right. Hey guys, if you're joining us on Facebook or Twitter or anything like that, come on over to YouTube. The link's on the screen. I'm going to be killing the feed to Meta and Twitter pretty soon. There's nothing wrong with that. It's just we want to treat YouTube as a library, and that's going to be the entire podcast is going to live on the YouTube channel. So come on over to YouTube. Going to be killing that feed in about 30 seconds. So, all right. So Chet, let me So let's say that's someone's defense, right? That's going to be, they're going to live and die. They're going to go to trial and they're like, you know what? Fuck it. I mean, let's talk about this. What's the difference between trial and a plea deal for people who don't know?
So a plea deal is where the state offers you something, and a plea agreement can either be a reduction in charge, or it can be an agreement to a sentence. So you could plead guilty as charged, but your plea deal could be that you are sentenced in the mitigated range. So a lot of states have adopted structured sentencing where for each charge based on your prior record, there's a sentence you would get in the presumptive range, which is right in the middle, like no aggravating factors, no mitigating factors. You could agree to be sentenced at the bottom of the mitigated range. So let's say you're pleading to second-degree murder, but they're agreeing to let you plead to the bottom of the mitigated range, which is, and then the judge has to agree to do that, and the judge signs off on that. Or you could agree to plead to, let's say, a lesser offense or a lesser included offense. So voluntary manslaughter, involuntary manslaughter, aggravated battery, something like that is going to be a less serious charge than what you originally charged with. A trial, on the other hand, it's yeah. Do you want to follow up on that?
Yeah. Why would that benefit the state or benefit people? I mean, does it generally benefit the person being charged, or does it generally benefit the state? Like, why would that be in the state's interest to put up forward a deal
for the certainty of a conviction? To prevent the victims from having to testify, to save resources. A trial is a big ordeal. You've got, an average prosecutor, might carry anywhere from 2 to 350 cases on their caseload. And if you do a jury trial of that magnitude, you're looking at doing nothing but handling that case for maybe a week, upwards of maybe a month for homicide cases. So it's a huge drain on resources. A lot of times the victims don't want to testify. They just want the thing to go away. And I tell people, having been on both sides, I tell people, look, it's all about risk aversion. You never know what a jury's going to do. You never know. They can get hung up on the weirdest things sometimes. And there's strong cases, there's weak cases, but the rule of thumb is there's no such thing as a slam dunk in law, because you don't know what's going to happen. Sometimes your case falls apart, and it might have been a slam dunk case for the state, and for whatever reason, they walk away with a not guilty verdict. And so you have to explain that to victims that, look, we'll go to trial, but I cannot guarantee you what's going to happen at trial. Whereas if we authorize this plea, yeah, maybe he gets out in 10, 15 years, but I can guarantee you that he's going to go to prison. He'll be a convicted felon, and we'll put a no contact order in place that will remain for the rest of his life. So it's an issue of risk aversion, and that works on both sides.
Right. All right. I guess here's another good question for you. I think is when would you and when would you not advise someone to take a deal? Like what would be the circumstances there where you're like, you know what, hey, this is going to be in your best interest, or something where it's like, you know what, we need to take this to trial because of what it means, what the consequences mean for your life. Like what kind of situations would you advise for yes or yay or nay on a deal?
That's a great question, and honestly, this is a very murky area ethically, because one of the things we're not allowed to answer is that ultimate question that the client asks: what would you do?
Yeah.
What would you do if you were in my situation? I can't answer that question. And I tell people that I can't answer that because I'm not looking at the consequences. Right. You're the one that's going to do the time. You're the one that has the consequences. What I look at, though, it's kind of a calculus. I look at the facts. Okay, let's say I'm looking at this from the defense side. So I'm just letting everybody know that this analysis is going to be from the defense side. Mm-hmm. How strong is the case? All right. If it's a super strong case, and I think to myself, what is the likelihood that they're going to be convicted as charged? Mm-hmm. And I think about that. I kind of come up with a number in my head, although even that's like, you're not really supposed to, I shouldn't say supposed to, but it's not advisable to give clients numbers like, hey, I think you got a 25% chance of a not guilty. Cause I mean, you're totally just pulling that out of your rear end, but so if it's like, all right, 90% chance he's going to get convicted. There's not really any good facts in mitigation. He's probably going to be sentenced in the mitigated range. So in all likelihood and all probability, I can look at the sentencing chart and say, this is what most likely you're going to be convicted of, and this is what you're going to be sentenced to. If the offer is substantially less than that, I'm going to tell him, look, statistically, you're going to end up better taking this plea, because now some prosecutors' offices are bad about making offers that are basically what you would get if you go to trial, or just a little. I mean, I'm serious. Yeah. And there's some, and it's like you have to school them. You have to explain to them, like, look, you're offering my guy 90 months. If we go to trial and lose, he's going to get 100 months. You haven't really incentivized me to not go to trial and just hope that you guys slip and fall and screw up some evidence, and then he walks. So you kind of have to look at, it's like going to Vegas. You kind of have to think about your odds, think about how much money's on the table, and then just think, okay, like, what do I stand to lose and what do I stand to gain from a statistical standpoint?
Right. And so it sounds like that, the consequences, as far as like what it means to those people and what impact it's going to have on their lives, I think it's something that people really had to have good judgment on. And I don't think, I would say that's something that people don't really take into consideration. And like you said earlier, as far as like that, it's a total character assassination. I mean, like, I don't think people understand, like, when the media gets involved, and like I always bring up the George Zimmerman case a lot, because George Zimmerman, he's a white Hispanic. Like, I'm a white Hispanic, right? There's nothing, and I'm incredibly, I'm ambiguously ethnic, as they say, and as we talked about with Nick yesterday, ethnically fluid. So it's like, but when his trial came down, and like the media, it was in the media's interest to make him look whiter every single time, and to paint that picture. I mean, we didn't find out that he was kind of a shit person until after the fact, but they really went after him and made him a social pariah, right? I mean, and I think that's something that people don't really appreciate and don't really like. Why don't you do this? let's say, we'll just kind of just pretend, right? We'll just let's say I'm on the stand. You ask me like, well, something that like my defense is, well, I was in fear for my life, and that's why I shot the guy. Like, what as a prosecutor, right? Just putting on your prosecutor hat.
Mhm.
What would your line of questioning be like, and what would you try to basically convince the jury? Like, what would be objectively something you're trying to talk to the jury about as a prosecutor if that was my defense?
So, and it's you specifically, John Valentine?
Yeah, sure.
Okay. So I'd probably say, Mr. Valentine, you're involved in martial arts, correct?
Yep.
How long have you been training martial arts?
About 15 years or so.
Okay. You're a black belt, in fact, right?
Yep.
And that's Brazilian Jiu-Jitsu?
Yes.
And that's the martial art that that dominated the UFC in the early years.
Yes.
In fact, most people, you could probably be an expert witness in a Brazilian Jiu-Jitsu or martial arts case, right?
Yes.
You would agree, would you not, that Brazilian Jiu-Jitsu is the art of strangling and dismembering people?
Yes.
You're an expert in choking people.
Yes.
You're an expert in breaking people's limbs.
Yes.
Do you run a school?
Nope.
You don't run a school, but you attend jiu-jitsu classes regularly, right?
Yes.
What sort of happens when a new person walks into a gym and rolls with you for the first time and they have no prior training? How much effort does it take for you to submit them or choke them out?
Takes almost none.
Okay.
Mm-hmm.
Now, this person that you shot, did you have any reason to believe that they had any formal training?
No.
In fact, they would probably be more akin to that person walking in off the street for their first jiu-jitsu class. Would you agree with that?
Yes.
Okay. And you want the jury to believe that you were in fear of death or serious bodily injury against somebody that you just testified to takes almost zero effort for you to break their limbs.
Fuck, I'm fucking scared now. Yeah. So yeah, man. Like I don't like it. I don't.
Yeah,
like
right.
It,
it sucks.
I don't like it. So, all right. Let's get into a case. Let's get into a situation here, right? I'm gonna go ahead and hit my screen share, right? Because, there are certain situations where there's kind of let's say like that there's like a no-win situation, right? And it's just things happen. You don't really know how that's going to happen. And then, shit just works out. So let's, right. We're going to go ahead and talk about this. Oop, here we go. Is that working?
Yeah, I see that.
All right. So we're going to look at this video right quick and let's see, let's break this down.
Sweet.
All right, guys, there didn't be no sound on this, but the sound is just music. You can't even hear any dialogue here. So, all right, definitely looks like a contentious conversation.
Yeah. They're looking at the phone, and then yeah.
Oh, there you go. Now he's convulsing on the ground. Guys, if you ever see somebody like that, like season up, best thing for you to do is turn them on their side. Okay, now we got the lady there likely calling authorities, and our driver in the Chevy came out. Looks like he's pleading his case. So the thing here, the caption on this video says "one shot knockout gets airlifted to the hospital." So, all right. So let's talk about that, Chip.
Yeah.
I mean, that's a pretty contentious situation, and I'm sure you've seen it, especially now living in Dallas. Like there's just these road rage incidents
Oh,
that
yeah.
really escalate off of silly, a silly thing, and it just kind of all this like to me, just from my perspective, a lot of it seems incredibly unnecessary. Like if somebody's like approaching your car like that and they're really amped up, maybe not get out, right?
Yep.
Maybe like call the cops, let the cops kind of calm the situation down, because it's like you just can't reason with people that are enraged, right? So that's just my protect. Let's talk about this from your standpoint. How would you handle this from a prosecution standpoint, right? This is you watching this video, they're hired you. This guy is he's he's an old man driving a blue Chevy. Some young buck comes and approaches him, sticks his finger in his chest and whatnot, and he hits him and then sends him to the hospital with
Yeah.
with some probably some. I mean, he bumped his head on the way down, so he probably got some permanent brain damage of some kind, some serious TBI. So, like, how do you handle that from a prosecution perspective?
Well, what you have to do is you have to be able to separate the ultimate injury
Mhm.
that actually resulted from the conduct of the defendant.
Mhm.
It's not, because it's not a civil case; it's a criminal case. But I will touch on at the end a little bit on some of the civil implications. But from the criminal implications,
Mhm.
you simply walk. It's sort of an algorithm, if you will, on how you do this analysis. You
Okay.
have to first figure out who was the initial aggressor. Okay.
Right.
Now, some people would say, "Oh, he got out of his car. He was an initial aggressor." I don't agree with that. I 100% agree with you that what he maybe morally, socially should have done was stay in his car if that's possible. But
Mhm.
certainly, legally, you are allowed to get out of your car and have a conversation with somebody.
Right.
If you didn't, if you were to come to a different conclusion, everybody would get charged with hit and run because you're supposed to exchange insurance information after an accident. I mean, you get into an accident, you're supposed to get it, you get out of your car, you walk up, "Hey, you okay? Here's my insurance card." Maybe a few words are exchanged, but that does not just because someone got out of their car does not legally translate them into the initial aggressor.
Mhm.
So that's kind of the first misconception that I want to put to the side. Once again, we don't, I say all this with a grain of salt. We can't hear who's saying what. We can't hear what exactly the words were that were being exchanged. So,
Mhm.
maybe there was something in context that might change that. But from just what it looks like you said, looks like two people that are having maybe a heated conversation about, somebody bumped into them or maybe cut them off or whatever. The guy is standing with his back to the car. The door's open. So what I'm looking for is who's boxed in and who's not, right? The young guy
Mhm.
could easily walk away or disengage if he wanted to. The older guy can't.
Mhm.
So that's kind of one of the things I'm thinking about also. I'm also looking at the old guy takes no sort of physically aggressive posture. He's not bowing up. He's not raising balled up fists. He has his phone in his hand that you can kind of see him, moving around and looking at. The first person that commits a battery is the younger person. And for those
Mhm.
of you who don't know, knocking something out of someone's hand is considered a battery. The rule of thumb is if something is sort of an extension of you or you're holding on to it,
Mhm.
striking that object is also a battery.
I didn't know that.
Yeah. The case that they teach you in law school, and there's civil battery also, so it's in context of civil battery. But
Mhm.
somebody comes up and hits your dog that you're walking, and that dog's on a leash, could technically be considered a battery.
All right.
Because the leash is attached to the dog and you're holding onto the leash. So, that's sort of the extreme interpretation of that rule. But certainly knocking a phone out of someone's hand is a battery. And if he's in the process of calling 911, it can also be an interference with 911 services, which in some states is a felony also. So there's those things to think about. He commits a battery.
Mhm.
Now, what happens after that initial battery? This is what this case comes down to. He punches him one time. He hits him with his left hand, which I don't know. We'd hopefully find out if he was left-handed or right-handed. But if he's right-handed, I think everybody knows that the right hand, a jab, is more of a space maker. It's more of a get off me hit than like, a right haymaker that's intending to knock somebody out, or at least you can make that argument, right?
Right.
He hits him one time and he doesn't follow up with any secondary hits. He doesn't follow up and start kicking him. He hits him one time, presumably to get him off of him, to stop a second or subsequent battery.
Mm-hmm.
The question then becomes, and this is what this case comes down to, is one closed fist punch to the face with your left hand, is that considered deadly force? Because you've got deadly and non-deadly. Yes. Was he authorized to use non-deadly force to respond to a battery? Yes. Is he authorized to use deadly force? No. So the question becomes, is punching somebody one time deadly force? And I don't think that it is. No, actually, there's no case law, there's no statute that would support that a single punch to the face is deadly force.
Yeah.
Converse that with multiple punches. If you have somebody up against the wall or you're in a mount position and you're just raining down multiple punches to the face, yeah, that can become deadly force. Or you got somebody up against the wall and it's just, they have no opportunity for escape and you're just continuing to rain down shots. That's deadly force. Another issue that would come up that I saw some people comment on was that he was not punching to stop an attack, but he was simply retaliating for the phone getting slapped out of his hand. Now, I would not say that's a frivolous argument. That is a valid argument. I have argued that before in court.
Right.
But the situation where I argued that and I actually argued that as a prosecutor, where two people were on the other side of a table. One person throws a book on the table or slides a book on the table, and the book hits the other person.
Yeah.
The person then walked around the table and slapped him. And the defense tried to argue, well, they started it. They committed the initial battery, which throwing a book at somebody is a battery.
Yeah.
And my client simply responded to that battery in self-defense. My argument was that was retaliation. That wasn't trying to stop a second book from being hit. I would distinguish that case with the video that we saw, that this guy hit him almost simultaneously to have the battery slapped out of his phone, or the phone slapped out of his hand. So it was reasonable that a second battery or a continued assault from that younger person was going to happen. That's my interpretation. That's how I would argue that. Obviously, people are free to come to a different conclusion if they want to.
Yeah, the other thing too, that kind of, I think we didn't really talk about too, whether we had in a thread in the combatives group and something else no one commented on was kind of how relevant is it that people's perceived value of like what a cell phone is now these days? Because people have their banking information, they've got all kinds of like very personal, very valuable information contained within their phone. I mean, it's a source of camera, so you're storing important memories on it. You've got your banking information. You have all these ways to connect. It's part of your work, and so on, right? Yeah. So, I think, would you say there's relevancy there as far as like what that meant, slapping that phone, and like as far as like for both parties, especially now this day, considering like how emotionally attached people are to their phones? Does that play a part at all?
I think it might from an emotional standpoint, but it's not necessarily going to make its way into the case just because the value on the phone, might make it let's say you were to slap or take someone's phone. Because of the price and the value of phones now, you might be committing a felony larceny or even a felony vandalism because the value of the items destroyed, or over whatever state threshold it is for felony. Right. You have the right to use non-deadly force to stop a theft. If somebody steals something from you, you can you can essentially grab them and try to take your goods or things back using non-deadly force. So,
Right.
I think it's just one more level of saying the guy had a right to put his hands on him, because not only was a battery committed, but arguably a larceny and or a vandalism occurred. It's just that it's not, the value of the phone doesn't necessarily change whether he was allowed to use deadly force versus non-deadly force. But like I said, I would just come back to the fact that I don't think it's not foreseeable that hitting somebody one time is going to cause a TBI or is going to cause, serious bodily injury.
Yeah. And I think this part is where like the martial artist in you is actually is very, let's say, in tune to where there's a lot of truth to that. I mean, you're training MMA now pretty often, and you've been training for a while. Guys, as a purple belt in jiu-jitsu, you know a lot of jiu-jitsu. You know a lot. At that point, you're mostly refining things and kind of, you're in a situation where, like, if Chet gets you in one hole, you can expect at least 2 or 3 more coming after that, right? If you try to escape. So, and I bring that up. The reason why it's relevant, I bring that up, is because, like, guys, we're watching people spar, professional fighters, people who are really dedicated to their craft, and like, how often do we see people get dropped and, you know what I mean, from one punch? I mean,
Yeah.
it's a rare thing, because we're literally involved in thousands, or innumerable amounts of simulated fights, and it's just like how difficult it is to drop somebody. I mean, I know you I know every guy out there really believes that they've got that one hitter quitter in them, but it's comparatively, it's actually quite rare. Would you agree?
Yeah, for sure.
Yeah. So, yeah, I mean, I know it's probably I'm going to generate the rage now on all 3 people watching. But, all right. So let's say, let's talk about this too. Like, what do you think is something people should invest in, as far as some type of legal protections, right? Or some type of knowledge? Like, what do you think people should, as far as making sure that they don't end up being prosecuted? Like, what do you think is kind of the main skill they need to invest in, or maybe some type of trust or a retainer, something like, where do you think people should put their time and effort into and make sure that they're not going to end up in a legal bind?
Yeah, well, I don't think that those CCW insurance policies that people talk about are a bad thing.
Mm-hmm.
I think they're good. I do think that it's important that you know what questions to ask those programs or those policies. For example, what's the implication of me taking a plea bargain? Because some of those things, it says like, it's sort of premised on you being found not guilty or charges being dropped. It assumes that you're in the right. And my concern would be, all right, I've racked up $180,000 in legal fees, which this policy is going to pay.
Mm-hmm.
And then the state comes at me with, hey, just plead guilty to misdemeanor battery, be on probation, and we'll make this whole thing go away. And I'm like, I'm wanting to jump at that, not because I think I'm in the wrong, but because I'm charged with second-degree murder or voluntary manslaughter, and looking at the deprivation of decades of my life versus having a little misdemeanor on my record and doing, 6 months, 12 months of probation. From a risk-averse standpoint, I want to take that. But is that policy going to look at that as an admission of guilt? And are they going to cover me? What's their bond policies? Like, how much bond do they put up? And is that something that is able to be just credited towards a bondsman? Or is that the total amount? And then what's the typical bond in my jurisdiction for a second-degree murder or a voluntary manslaughter? If you look, and this place is like, yeah, we give you $10,000 in bond money. And you're like, oh, that sounds great, until you find out that for second-degree murder, they're usually putting up the judges are usually giving you $500,000 bonds. So like, you just kind of try to educate yourself on the policy, and maybe talk with a criminal lawyer that can help you like know what questions to ask.
Yeah.
So that's a good thing. I'd say
And hold on real quick.
Yeah.
So, and guys, that's a very, very important. I don't think you guys realize how important that piece of advice is. Like well over 90% of cases end in a plea deal. So that particular advice right there, that shit is worth gold. So make sure you guys are listening. Go ahead, Jeff.
No, yeah, that's educate yourself, but make sure the source of your information is valid, and there's a lot of information out there, but there's not a lot of really good information as far as self-defense law. Just, you know what?
Mhm.
I mean, look, there's guys like me, there's other guys out there that, are willing to talk to you. And if you have questions about where do I need to go to get this information, it's not as hard as people would think to simply pull up your state statute, read your state statute. Another really important thing is read your jury instructions.
Mhm.
Like you actually, I mean, most states, I can only think of one or two states off the top of my head that don't have this. They have codified standard jury instructions, which for those of you that don't know, that's what the jury will be read when deciding your guilt. It's literally the judge is going to sit there and after the case is over, he's going to read to them the definition of voluntary manslaughter. They're going to read the definition of self-defense. They're going to read to the jury when a person is allowed to use deadly force in self-defense. So wouldn't it be great to know if a jury is going to be deciding your fate? Wouldn't it be great to know exactly what they're going to be told in forming judgment about you? Yep. So, read your state's jury instructions so that you can kind of get a picture of how they're going to make the decision.
This is really good advice, and I hope there's not like a invoice in the mail right now. So I'm gonna just tell you right now, guys.
It's about tree fitting.
Yeah, right. About be true. So, guys, look, that that's something I didn't know until like we were talking before, and then you sent it to me as far as like the state statute for New Mexico, and right, because I mean the burden on us as like if we want to be like the good guys, right, is that we have to be the adults in the room. Like we never get that chance to be emotionally impulsive, especially if we're walking around with something that's on our hip that can basically make people die in an instant. So we have to always be the adult in the room, and we always have to use logic and guidance, right? Because if we get emotional, we get impulsive. That's how a lot of times how we end up in trouble. So when you showed me that whole thing, because the important thing is that the point that I think people need to understand is that the jury is kind of removed. They're just, you got one side represent the defense presenting their facts, the prosecution presenting their facts, and they say about, hey, this is what happened, right? And like any conversation, the truth is always somewhere in the middle. So these people are now going to deliberate and basically agree to what they think the truth is, right? And like, hey, would I put myself there? And then from that, then they have this definition as well. And like, hey, based on the truth that we agree to, did this person meet this criteria as far as being able, or did they go outside of this criteria? And I don't think people can really appreciate that. And the other side is like when you're a highly trained person, and I think people have a hard time. It's like the circles we run in, right? Like we've got Matt Larson, Craig Douglas, Ben Albin, Redbeard, Cliff Byerly, and Fletch Fuller, and a lot of other guys, right? So it's like we end up getting. I think a lot of times that can give us some blinders where we start thinking that our jury is going to have that same type of lens of viewing the world, right? Like, what do you say to that?
No, that's a great point. I mean, just remembering that most juries that I found are at or near retirement and female, simply because, and that's been in multiple jurisdictions. You got people that can't get out of jury duty, for whatever reason.
Yeah.
For what, and I don't know I mean, I don't know why this usually is the case, but there's a plethora of retired women on the jury. So your Aunt Martha, your lady that bakes brownies for the church, fundraiser or whatever. Yeah, you do get some younger people, occasionally, but the overwhelming majority of people on the jury are not, combatives practitioners, are not martial arts people, are not, you might have your NRA member here and there and stuff. But you've got to be able, better hope to be able to articulate to the 59-year-old, retired or 59-year-old school teacher that's, has the attitude of, well, you always tell the teacher, you don't need to fight back. Like you need to understand that those people are going to be going to be the jury. If I get charged with something, it's not going to be John Valentine, Ben Aubin, and Fletch Fuller as a panel deciding whether or not I use the appropriate tactics.
Right.
Like that's not going to be how I'm judged.
Right.
It's going to be, and I think like you said, we kind of fall into that trap of like, okay, like I know what the industry leaders would do and would teach and everything. And so as long as I do that, I survive. But like you said a lot of times, it's not just surviving the fight, it's surviving the aftermath. So yeah, no.
Because I mean, if I choke you out or make you bleed out, but then I got to go and protect my booty for 20 years, that's a loss. So
yeah. And the one thing that I want to say to people, and I did a video on this a while back, but it's this concept of creating the transcript for your trial, and just remembering that every single day that you live, you're creating the transcript for your eventual trial. And what I mean by that is there are certain rules of evidence that allows character evidence, propensity for violence or nonviolence to come in. How much would I like it to be able, if I had to use deadly force, I would love to have a room full of people that I could call as witnesses that could actually testify to my character for peacefulness and for my propensity to avoid conflict and to de-escalate. Right. I was actually thinking about this, the other day, where it's like, you've got some people that are gym bullies and they have a reputation for like beating up white belts and injuring people and stuff. Well, if they get charged with something and then, they start investigating, they find out they train martial arts, they start talking to people at the gym, that reputation for injuring white belts and injuring new people, that could somehow come up,
white belts are people. They're not food.
What kind of bumper stickers do you put on your car? What kind of t-shirts do you wear? What kind of stuff do you post on social media? Are you creating a transcript? Are you creating a persona that you would feel comfortable putting in front of a jury that just saw you shoot somebody that's unarmed, but you thought they were armed because it was nighttime or because they were reaching in their pocket or whatever? So you're already working from a legal deficit and a factual deficit. When the prosecution starts putting things like your Facebook post where you're like, a picture of the new AK that you bought, it's like, I wish a motherfucker would, or the t-shirt that you happen to be wearing on the day of the incident, which gets admitted into evidence because they took photographs of blood that says, I have a beautiful daughter. If you mess with her, they'll never find your body. Like stuff like that. It's like, look, I'm not trying to tell people what to do, what to wear, whatever, but just being mindful of the fact that every day that you live, you are creating the transcript for your trial.
No, put that guy away forever. Just for the cringe factor alone. Yeah. Forever. Under the jail. Straight to jail. So, Chet, let's, we've been mulling over this idea as far as, having you put together a webinar and all this. And I think it's something that, I think is really important for you specifically. I think, and I think because now we're seeing kind of combatives come out as more of a, and guys, let me just back up a step. Shout out to the suited shooters. Okay, some of you motherfuckers need to learn how to dress. All right, so Okay. So, with that in mind, guys, I want to really, with your unique kind of blend of skills, why do you think it's important if people are going to be getting quality training and really investing in themselves and really putting that time and that effort towards becoming a more capable, competent person in these in extremist events, right? Circumstances. Why do you think it's important for them to find somebody like you as a defense, or at least kind of get you as a consultant for
Yeah.
as they kind of move forward in their path, right?
Well, I think if you're doing combatives and you're doing the force on force training and you're doing all the things that, guys like you and guys like, Craig Douglas and Ben Abbott, teach and promote, it's sort of just when you take that legal aspect and you kind of plug it in there, it kind of puts that stuff into context. So as you're training and as you're doing the combatives, you're running it through the mental filter of when am I going to be justified in doing this? As opposed to just being that guy who trains in fight weapon access all the time and becomes so good at it
Yeah.
that when you're carrying one time, some guy slaps you in the face and you just instinctively do a one-handed garment draw, pull out your gun and shoot him.
Right.
And just because you've trained that so many times in force on force of weapon access and all this stuff, but you've never had to stop and think like, okay, when am I actually justified in going to that level?
Yep. Yep. Yeah, this is kind of the reason why we put that in-fight weapon access model that we talked about. That I sent it out to you before we went public. As far as like having that scale, right? Because I think people will generally look at like non-lethal de-escalation, and then lethal force is kind of as a binary solution, right? And I don't think they recognize that there is a spectrum of things that happen to where lethal force becomes a reasonable thing. And I think people are not they get caught up into where people will they want you to just be bought into how they felt, what they experienced. But it's like it's really I think it's really impossible for people to do that, because it's like every fight is unique, and they're all the factors are just kind of they're unique to the circumstances, to the time of day. The weather can play a part. It's so many different things that can play a part as far as like why people do certain things. So it's like to take into like, well, this is me, as opposed to like these are the principles and this is like what a reasonable person would do. I think that's something that people aren't really putting enough attention and effort into. Does that make sense?
Oh, absolutely. No, you're right.
Yeah.
Absolutely.
Okay. So Chet, we're approaching the hour mark. So we're gonna go ahead and call it here. But I wanna get people, how do people get in touch with you? And what can they look at as far as, putting you on a retainer, as far as trying to get you out there and help them if they ever find themselves in a legal bind?
Yeah. So right now I'm licensed in North Carolina and South Carolina. We'll actually be moving to Greenville, South Carolina next year. So I plan to resume a criminal practice there pretty soon. And there may be some news pretty soon about a firm that I may be joining that's, kind of still in the works or whatever, but I'll definitely let you know about that. Obviously, I could, if a case happens, I could talk to somebody about the case. If it's in that state, if it's not, there's ways that I can take a case that's out of my jurisdiction on like a one case basis. For those instructors out there, I mean, just ongoing training, obviously not trying to think about worst case scenario of you actually being charged with something. Would love to, maybe partner with some folks and putting together a class. I've already talked about that with Ben with Redbeard. So kind of been talking about that. But if there's a trainer, an academy, someone that wants to do a 1 day or half day thing, just reach out to me. Facebook, Instagram, whatever. Chet Palumbo at Gmail. That's super easy. It's Lawyer Grappler on Instagram. So yeah, I'm pretty easy to get in touch with. And, look, this isn't like really a revenue source for me. It's something that I'm just really interested in, and I like being a part of the community. So, yeah, I just, whatever they need, whatever they want, we'll figure out something that works for them, is
Yeah.
practical economically. So
Yeah. Let's so we just got 2 comments here. I was gonna wrap up, but I think this is a really good question. Um, let's look at this. What's the thought about collecting subject matter experts that can testify on your behalf as expert witnesses?
I think that's a great idea, honestly. And I've actually thought about, and we never really talked about it, but it'd be cool if in the combatives community, we compiled a list of people that were qualified and willing to be expert witnesses in case we need to call on that. So we sort of have a pool of
Mhm.
people. We know what their fee is and everything. But no, Alex, I think that's a fantastic idea.
Yeah. So that's yeah. And yeah, guys, if you need an expert witness, I can't think of anybody uh, much better than Chet. So you know what I mean. Send him
Appreciate
money and bring him out. So if you if you want to be free and not have to protect your booty. Well, Chet, yeah, bro, I appreciate it, man. This is a good time, and yeah, we definitely got to do some more of these. So
Yeah.
I think guys, if you're interested in me bringing Chet on and then kind of breaking down some street fights and or some incidents and seeing how he would handle it from a legal perspective, let me know in the comments. Make sure you guys are sharing this with your friends, like, subscribe, all that jazz. Well, all right, we're gonna have Chet on again, but yeah, Chet, appreciate you, bro.
Hey,
Thank you.
John, thank you. It's a huge honor.
Yeah, bro.
Hey,
Huge
thanks,
honor
man.
for me.
Huge
All
honor for me.
right.